SJC-13112, Commonwealth versus West Doughty.
Okay, Attorney Baylor.
Good morning. May it please the court. Jeffrey Baylor for West Doughty. In this case, we contend that at minimum, a number of issues combined to warrant a new trial. First off, we contend that the mistrial should have been declared when evidence of rape was introduced into the trial. Now, there was initially a rape charge that was
Can you just explain how evidence of rape was actually admitted to trial? Because my understanding is that there was evidence of a statement that the witness heard from the victim.
Right. That the witness testified that she heard one of the decedents say, "If you're going to rape me, kill me first." And before that time, there was no mention of rape whatsoever in the case. So, okay, so it's not saying she knew that there was a rape, but it's bringing rape into the case. The rape charge was no prost. There was an agreement that no testimony would be given about statements relating to rape. The trial counsel was so concerned about this witness that before she testified, she brought it to the judge's attention, and the Commonwealth met with the witness to be sure that she was not going to mention anything relating to sounds of sex or anything.
But isn't that different from the statement she heard the victim say? So I'm just trying to make sure. I'm not sure exactly what the judge said is excluded. What did the judge say?
You mean, there was an agreement, there was some testimony that this witness overheard someone else saying, talking about a rape occurring. So there was no testimony allowed regarding those statements. And then before her testimony, trial counsel said that she shouldn't be testifying anything to do with rape or any noises that she might have heard that would have indicated it. So the DA met with her and went through it, and then there was questioning where she was repeatedly asked, well, what did you hear? What did you hear? What did you hear? And finally she said, I heard that statement, if you're going to rape me, kill me first. So we contend that, trial counsel and in the rulings did everything to keep rape out of this case. And then there was this testimony that totally changed the tenor of the whole case. The jury was likely, well, the jury may well have found that, the defendant's whole defense that this was second degree on manslaughter was no longer valid, being just overwhelmed by the possibility of a rape occurring. And beyond this, when the indictments were read to the jury and later on given to them before deliberations, they never renumbered the indictments so that they're left to see it goes from like 102 to 104, that there's an indictment removed. So, I mean, a logical conclusion would have been that, no, oh, there's a rape. What, this guy, where's the rape?
Counsel, I'm going to, if I could, this trial was a 2-week trial, and as far as I could read, this is the only comment that was made with respect to that. This one statement about what the witness testified to overhearing the victim say, right?
That's true.
So I'm wondering where your contention is that this overwhelmed the jury, where there was this one isolated statement in light of all of the evidence that was presented. How please take me through your math. Because,
I mean, first of all, rape is a pretty shocking thing to bring up in any trial, and in a trial where nothing is leading to this, and all of a sudden, out of the blue, this rape information comes in, And clearly, the parties recognized that this was going to be very prejudicial if it came in, and agreed that it shouldn't come in since the rape charge was no pros. And there was not an argument that no killing occurred, only that this killing was a second degree manslaughter. So we contend that this put it over the edge, in prejudicing the case against Mr. Doughty.
So what did the trial court judge say you can't do? I know you say the parties agreed.
Right.
What did the trial court judge say the Commonwealth couldn't do with this witness?
There was not really a ruling that from the trial judge because of this agreement that there would be no evidence regarding the rape between the parties. There was a written motion and an agreement that these certain statements relating to the rape wouldn't come in. Mm-hmm. And then before her testimony, trial counsel brought out, I want to make sure that she doesn't mention the rape. There was that meeting. So it was by agreement rather than the judge recognized that this shouldn't come in, but.
Well, I don't know about that. So first of all, as Chief Justice mentioned initially, there is no evidence presented of a rape occurring initially. But secondly, it seems certainly prudent that Judge Feely didn't let this evidence in. But the fact that she's so scared and troubled that in the conversation where she makes other comments manifesting how troubled she is, that she's saying, kill me if you're going to rape me, goes poignantly and with serious probative value to the issue of conscious pain and suffering, one of the Canine factors available at the time. So I'm having a hard time grabbing where is it that Judge Feely abuses his discretion in denying motion for mistrial, particularly in the context of Justice George's point of once in this relatively lengthy trial.
Because something like rape really just changes everything in the case. They're going along, the argument is that it was second degree, there was no premeditation or manslaughter, and then this whole rape part comes in. Yeah, and it could have been show that there was premeditation or something, statement like this, but the court and all the parties recognize the hugely prejudicial nature of bringing rape into the case. Yeah, to the extent, and also there was no voir dire from these jurors about any rape or sexual assault, prejudices at the beginning of the case. So there was not even an opportunity for the defendant to look into this matter until it was blurted out during the trial.
Although, is that true? I mean, because they fought over the issue of whether the rape evidence, because there's other evidence of a sexual assault. So this is not coming as a complete surprise, right?
I don't know that there was other evidence.
I thought there's evidence that someone, again, it's excluded, but there's evidence that someone heard, some sex going on, essentially, right?
So you're talking about the evidence that was excluded?
Yeah.
Yes, there was.
So it's not like this whole thing is a giant surprise to the defense counsel.
But, I mean, it was, when there was no pros and there was this agreement, there was no thought that any of this evidence was going to come in.
I know it's not expected to come in, but it's not as if the defense counsel has never heard of this and suddenly, out of the blue, something is striking.
True, but in the case where it was all excluded, there was no voir dire or anything of the jurors or anything about, that could relate to this. So it wasn't a surprise. It wasn't a surprise that there was test evidence about it, but it was excluded evidence. So it was a surprise that it was going to come in. And trial counsel did everything he could to prevent it from coming in by even mentioning it right before her testimony. If there's no further questions on the issue, I'd like to move to some of the jury instruction issues. We contend that there should have been a mental impairment instruction as part of the murder charge. There was a written motion for this language to be added into the murder charge, which was denied. The judge finding that there was not sufficient evidence for mental impairment to be included in the charge. I mean, the model charge includes the jury should consider use of drugs and mental impairment in terms of looking at intent. And the judge did give the drug part, but refused to give the mental impairment part. And we contend that both should have been given because there was more than ample evidence of mental impairment. Now, this court has found that there was no expert testimony as to his psychiatric condition here. But this court has found that that is not needed to require the mental impairment instruction. All that is required is lay testimony or other evidence in the case. And here we contend that there was long drug use indicating his impairment, but also testimony from many witnesses, for example, saying that he was a weird dude, he was an idiot, he was actively...
Those are not mental, being an idiot is not,
Well,
yeah,
but
weird,
I mean,
being weird is also not mental impairment, right?
and also that he was acting strangely. Police, when they arrested him, found...
Also not, I mean, you're asking us to push the law pretty intensely, right? I believe Justice Lowy's written a case that sort of sets out the standards for that, right? And this doesn't come close to meeting those standards, does it?
Well, we're not saying that he was mentally impaired in terms of, for example, like criminal responsibility. Mm-hmm. We're just saying that the model rule seems to say that this is just one factor for the court, for the jury to look at in general when making a determination as to impairment.
What are your thoughts on Commonwealth versus Santiago and comparing and contrasting it to the situation here?
I think that, I'm trying to remember exactly the facts of Santiago. I just read it like 2 days ago, and I just, could you refresh my memory a little bit?
I can't do your job,
Okay.
but what I can do is tell you that you've got a certain amount of evidence in these lay witness cases that reach the threshold of mental impairment that can be significantly contrasted with the evidence here.
Right, well, that's true. There are cases that have more evidence of mental impairment, and I know the Commonwealth cites some of them in their brief. But it doesn't mean that this is not sufficient. It just means that there was more in those cases. I mean, here...
Well, in those cases, there is evidence of some sort of link between, the oddity that was observed in the behavior of the defendant, the drug use and or alcohol abuse, and the mental impairment. Here, it seems like lay people observe that he's odd.
They recognize that he was odd, acting weird, acting strange.
Right, and so I think what Santiago stands for is the proposition that simply is not enough, that you have to have some link between these lay observations and the impairment that you're suggesting.
I didn't believe that Santiago went that far. I believe that, Santiago in other cases had more evidence of impairment, but it's not saying that here it wasn't enough. I mean, I couldn't find a case where there's just sort of lay opinion about, lay comments about a defendant where there was an issue about whether that instruction should be given. I mean, to me, it seems like anything, it's a low bar just to give it to the jury. Let the jury make their decision based on, his drug use, his long-term drug use, did that impair him mentally? I mean, I think the jury has to be able to consider the mental impact of his drug use. And it seems like from the model instruction that there's sort of, the two things go together. I have a copy of the instruction, which,
Counsel, can you refresh my recollection? Was there any affirmative motion by the defense to say, I'd like to offer these witnesses on the issue of the defendant's mental impairment?
no, there was not.
So this all happened in real time?
You mean
Through the questions and answers of the
Right,
witnesses that you
yes.
claim undergird the mental impairment theory?
Yes, I mean, and I'm not saying that, it doesn't have to be mental impairment enough to say he's not responsible or anything. It seems like from the model instruction that it's just,
No, but the point I'm making is there wasn't any kind of voir dire of these witnesses to this specific issue that the judge could have had a more comprehensive idea of.
there was not.
Okay, so we're at an abuse of discretion standard, right?
True, yes.
So tell me how specifically the judge abused his discretion by not giving you what you're saying he should have.
Because there was enough evidence here that there should, to show.
But that's an advocate's lens. Give me some real stuff that I can go back and weigh and say,
Well, as I mentioned-
okay, here's because you do have what Justice Lowy and Justice Wendland is alluding to with Santiago, which is a much higher bar. I mean, let's just be real. It's much more of a showing in that case than we have here.
True.
So tell me how you get there.
Well, it is much more of a showing, but it doesn't say that that's what is required. It just says in that case, this is what the showing was. So here, as I said before, there was long-term drug use, that evidence that it was leading to his mental issues. And then numerous witnesses testified to his behavior, that he was strange, he was weird. The police said that he was an odd, weird person. When he was arrested, he did these weird things that are outlined in my brief, like laughing with the police, like asking which side their gun was on.
Sure, I mean, but you said something that I disagree with, that the jury just doesn't get anything, right? We still have a relevancy bar that the judge has to look to what the jury ultimately gets. You've got people that the police don't know him. I mean, that what they wouldn't have a basis to give a lay opinion on that. And so when you have in real time, this is kind of evidence coming in, judge makes a determination that's not relevant, he's not going to give it. So I'm just struggling with this.
Well, we're saying that the bar is very low for this jury instruction.
Is it lower than relevance?
It's not lower than relevance, but I'm saying it's low in terms of what evidence. This court recognizes that it could be lay evidence, it can be expert evidence, it can be evidence from the case. And in the model jury instructions, I'll just briefly read it. It says, you may consider any credible evidence that the defendant suffered from mental impairment or was affected by the consumption of alcohol or drugs. So to me, that's just basically the same instruction. If there's drug use, that comes with mental impairment. And the model is saying, consider his mind, regardless of where it comes from, his drug use or otherwise. So there was these things that showed that he was not an ordinary person, but also his drug use. So that, we say that, at least here, there was sufficient evidence for that instruction, just to leave it to the jury to consider his mental character as part of the whole determination of intent. I say that my time's running out. I'd be happy to address any of the other issues. Otherwise, I'll rely on my brief.
Thank you. Attorney Jansen.
Good morning. May it please the court, Catherine Jansen on behalf of the Commonwealth. The Commonwealth respectfully requests that the court affirm the defendant's 2 first-degree murder convictions for the murders of Jennifer O'Connor and Mark Greenlaw, along with his other related convictions. I would also like to acknowledge that the presence of the victims' families in the courtroom and watching via the live stream. I would start first with the mistrial issue. What was excluded from evidence by agreement of the parties, and what Judge Feely said was that the witness Kaminsky heard sex sounds, that she heard Heb say he's leaving DNA in her, and that he's having sex with Jennifer. So that was what was excluded. What happened at trial is after the prosecutor spoke with Kaminsky about what was excluded and questioning about what she heard Jennifer, or she didn't know it was Jennifer, but what she heard a woman downstairs saying. She was eliciting that she asked to leave, she wanted to go see her father, and when she asked if she heard anything else, she unexpectedly said, if you're going to rape me, kill me first. And then the subsequent question to that was, did you hear anything else? And she said she heard whimpering. So I would first say, in good faith, the prosecutor did not expect this. It was clear the line of this questioning was to elicit the pain and suffering in the consciousness of knowing what was happening to her, of Jennifer, which was entirely proper and relevant to extreme atrocity and cruelty. And that being said, this was a fleeting single statement in a very lengthy trial. I think it's completely speculative to think the jury would make the leap that because the indictments were missing a number, that it had to be a rape charge. It could have been anything. And this was not mentioned by anybody else, another witness, not in opening, not in closing. And beyond that fact, to say that this would have had an impact on the jury, I would say is highly unlikely due to the traumatic and brutal nature of the murders in general, but specifically the murder of Jennifer O'Connor, where her throat was sliced 7 times to the point she was almost decapitated. And then the ME testified that there were stab wounds under each breast, which were consistent with being inflicted after those fatal neck wounds. I would just like to briefly address the mental impairment issue. I think the court hit the nail on the head. There needs to be more than just saying the defendant is weird and bizarre to rise to the level of lay testimony of a mental impairment. There needs to be a link either between long-term drug use and a mental impairment, that the defendant suffered from a mental impairment and that he had one that night. And at the end of the day, here, this was not the sole defense to first-degree murder. He was given a voluntary intoxication instruction due to his drug use of crack cocaine during that day and throughout the night. But I would suggest the evidence showed.
In Santiago, the instruction wasn't given, right?
That's correct, Your Honor.
In that case, there was evidence. Somebody called the defendant crazy. He had a concussion.
He was falling down.
Yeah, he had a concussion. He got hit in the face. All these different things that aren't here. And in that case, there was no instruction. Is that right?
Absolutely, and there was no error in not giving an instruction there, because there, not only was there extensive lay testimony as well as medical records showing the extent of the head injury from, I believe the defendant was punched earlier that night before the murder. What I took from that case was that there wasn't significant evidence of mental impairment because there was no link that this actually caused a mental impairment and caused a brain injury, and that it was linked to his conduct that night. And so there needs to be a link to the conduct that night, and that's what's missing here. Being weird and bizarre is not a mental impairment, and I would suggest any testimony from Dale Gerard saying that the defendant was acting stranger than normal the night after was because he was aware there was a police officer sitting on top of the driveway, and he was paranoid about that because he had just committed a murder. I would suggest his weirdness to the police officers was showing actually that he's smart. He's asking what side if they're right-handed or left-handed, looking to see what side their gun is holstered on, making comments about running. He enjoyed kind of hyping it up, I think. And so I would also suggest the evidence showed mental clarity. He had a plan. He told Heb that when you see me standing between the two lions, you know shit is about to happen. And then Kaminsky saw him go stand between 2 lions and then come back upstairs with a revolver. And when he heard Mark open the bathroom door downstairs, he went downstairs. And then immediately after the murder, Heb and the defendant are heard banging around downstairs. The bodies are being moved. He has Kaminsky clean the cabinets. He rolls the bodies in cellophane and puts them in body bags and wraps them in rugs. And then he puts the evidence of the murder in bags and douses everything in kerosene and threads a tube connected to a welding canister in anticipation of burning the house down and burning the evidence. So I think there's no question about mental clarity and that there was no error, and if there were, this is not a case that would require reversal. I would just briefly turn to my argument about the attempted arson indictment. While I recognize right now under the law, going all the way back to Peasley, there's a requirement that an overt act be pled in an indictment, I would suggest, I have two lines of argument. My first line of argument is that under Section 5A, which is a specific attempt statute, the concern in Peasley, as articulated in Martinez in the appeals court most recently, is obviated because the concern in Peasley, and my understanding of the case law and how it's developed, is that the line between preparation and near completion is very close and hard to draw. And so the requirement of pleading the overt act is necessary essentially to put the defendant to codify what specific acts of preparation are specific or substantial acts of attempt for the statute. And so when you're charged and the caption of the indictment or complaint says attempted arson under 266 Section 5A, you're on notice of what the preparatory acts are, what the overt acts are. And I would even suggest that the need to plead an overt act might be even antiquated at this point, as discussed by this court in Lorenzo, 438 Mass. 1018-2003. This court questioned whether we need to do that anymore and committed the issue to study. Nothing has come out of that since. So potentially the need to plead an overt act might not be needed anymore, because at the end of the day, the purpose of a complaint or indictment is to put a defendant on fair notice of the crime, to prepare his defense, and in any other circumstance, a bill of particulars, pretrial discovery, are also all when read with a complaint or indictment are sufficient. So if the court has any questions.
On that last point, is that an issue of subject matter jurisdiction? It seems like that's what the appeals court called it. And do you agree?
I believe the law is that if an overt act is not pled, then it fails to state, it's a jurisdictional issue, and if it fails to state essentially a crime, I guess is my understanding of it. And I guess my point would be...
Your understanding of subject matter jurisdiction is that if something fails to state a crime, it deprives the court of power to hear it?
That would be my understanding, although I might be wrong. But I guess my point also would be that this court should find there's no subject matter jurisdiction deprived. There's no jurisdictional issue here, because this court could find that, and as it has in other statutes, in senior...
My question is really sort of jurisdictional, right? If we don't have the power to decide this, it seems like you're asking us to decide something we have no power to decide. It's sort of somewhat circular. So I would suggest maybe calling it subject matter jurisdiction is not right.
Potentially, it's a term I would not use then, but I think what I'm asking is to revisit the principle of what's required in pleading attempt crimes.
But going back to something that Justice Kafker said a little while ago about the rape, this wasn't a surprise to the defendant, right? I mean,
Absolutely not.
We have the grand jury presentation, the grand jury testimony. There's no surprise here as to what the predicate overt acts were, the mathematics to this, with the bodies, the torch, and everything else.
Absolutely not. It was all part of the grand jury, and I would point the fact that when a grand jury is indicting a case, they are given instructions, they would necessarily have to find an overt act, especially an overt act sufficient under Section 5A, to even hand down an indictment. And the defendant had all that. So at the end of the day, when you're looking at whether or not there's fair notice, which is the point of an indictment, there was here, although I understand that if it's a jurisdictional issue, then we're kind of hamstrung. But I would suggest the court possibly revisit that issue in Lorenzo. If the court has no further questions, I'm happy to rest my brief on the remaining issues.